Hello, and welcome to Module 5, which is all about the ethics of privacy. Chapter 5 covers the invasion of our privacy by the government, traditional media, as well as marketers tracking social media behaviors. Chapters 6 and 7 deal with the invasion of advertising and commercial messages into our everyday life. The final portion of the presentation covers workplace privacy and reviews the ethics of FERPA privacy laws in educational institutions and HIPAA privacy laws in healthcare. These are regulations that every PR and advertising pro in these fields should know about. Now I'm going to let you manually click through most of this presentation at your own pace to review the summaries of the assigned cases, but this presentation is not a substitute for actually reading those cases, since Quiz 5 will cover them in detail. But before I turn it over to you, I'll first review some of the ways that someone's privacy can be invaded. First, through intruding on their solitude. This can happen to a private person who might be caught up in a media frenzy after a scandal or a tragedy, but it's also an issue for celebrities and their paparazzi who follow them everywhere. There's also an issue of disclosing embarrassing private information or publicizing information that puts a person in a false light that damages their reputation. This could be done by the media, but it could also be the subject of a lawsuit against someone who posts these things in a blog or on social media. You'll often see references to these privacy issues in a libel lawsuit, but they tap into a different set of laws, and the courts use a different set of criteria to judge their merit. The final issue is the appropriation of personality, which is related to privacy, since the law assumes that we have a right to our own likeness, and whether we want to see it posted in various places or not. While the courts allow the news media to include photos of people without their permission if they're part of a news story, and the public people like celebrities are typically considered fair game for news, but one's likeness cannot be used for commercial purposes, such as in an ad, a brochure, or website that's promoting a product without their permission and without the right to demand compensation. As we look at the cases on when it's ethical to invade someone's privacy, you'll want to consider these issues. Is the individual being treated with decency and fairness? Does a news story that releases private information have some redeeming social value to justify it? And is the individual's dignity maintained even with the privacy disclosure? Now, on the issue of appropriation of personality, I'll give you this example from early on in Barack Obama's presidency. Now, this is a legal concept, and it turns out that this particular example didn't have any legal standing, but it did raise ethical questions. Was it fair for a company to create these dolls with the names and likeness of the first daughters without their permission and with no compensation to them? Now, sometimes courts rule in favor of the celebrity, especially if their exact likeness is used. They picked up a picture of a celebrity and attached it to a product, etc. So if it's being used for commercial purposes, there's a much better chance that the person in the lawsuit will win. One such person who did was Vanna White, the famous letter turner on Wheel of Fortune. She once won an appropriation of personality lawsuit against Samsung, which had run a TV ad with a robot in a blonde wig and an evening gown turning letters. Now, obviously, this was not an exact likeness of her, but she argued that they were using her identity to help sell their product. And she was using this common law concept called her right to publicity. And in fact, in 1985, California passed a law based on this right, and it's called the Celebrity Rights Act. Now, PR and advertising professionals need to know that they can't use the likeness of a celebrity or their voice or other identifiable features without their permission and compensation. That's actually true of non-celebrities as well. You need to get their permission before you use their likeness on your product or in your brochure, or even on your web page. And this is in order to meet their right to publicity. Individuals also have a right to privacy, but this is often held for private individuals and less so for celebrities and those who become public figures by putting themselves into public debate or by becoming part of a news story. Those people have far less right to privacy as a private individual does. Now, sometimes we set ourselves up for public disclosure of embarrassing facts. And it's usually in this day and age because of something that we posted in a public forum. Here's a scenario that's all too common these days. So, as we move into the cases, Chapter 5's first case on Facebook and social media is going to go into this issue about, being way too trusting about what we're posting on social media. Case 20 is all about how the government has been able to obtain more of our private information since the Patriot Act came into being more than 15 years ago. And case 22 is about the trade-off between a family's right to privacy after a tragedy and the public's right to know interesting details about that tragedy and the media's right to gather and release those details. So with that, I'm going to let you read through the remaining slides on your own and have a good week.